18th of January, my lord has remanded back 4 or 5 writ petitions to the London Singh, restoring the file to the original file, my lord. Even today, the case status is showing disposed of. The cases are not being listed, and we are facing a lot of trouble. And the registry is informing that one of the files.
Situation of what?
No, the LPA was allowed, and my lord has remanded back the 5 writ petitions which were heard in the LPA matter, and my lord has been pleased to remand back all the writ petitions before the learned Singh for hearing on merit. So even after 4 months approximately, the registry is not updating the case status. It is still showing the disposed of. When I have requested them that kindly update the case status so that the writ petitions may be listed before the.
What is the date of disposal?
18th of January.
Why?
And till today, the registry is saying that since one of the writ petition has been missing, so we will not restore all the files. I am requesting that let that be reconstructed, and in the meantime, other writ petitions may be updated.
Let us see.
Lordship, investigation for the MJC.
एक
urgent matter, Lordship. MJC 240 of 2023 for restoration, Lordship.
Region में
Lordship.
Find out.
May I permitted to mention a case, Lordship. CWJC number 5244 of 2023, Lordship. This matter was heard by this honourable bench on 5/5/2023, Lordship, and direction was given to file counter affidavit, and further the petitioner was allowed to participate in future tender, Lordship. And however, this matter the order has not been uploaded on the website, Lordship. That is filed.
Not been uploaded.
Obliged, Lordship.
Lordship, on 2016 matter, Lordship. In this case, Lordship, respondents have granted me the second progression, but the consequential order they are not passing, and accordingly I am not getting the monetary benefits, Lordship. I am retired employee, Lordship.
Correct. What we should do?
Lordship, it may be, Lordship, listed in detail, Lordship.
What is that? MJC?
No, it is, Lordship, writ petition, Lordship.
It list.
Lordship.
Matter क्या है sir?
2016 matter.
I'll find out.
How it is before division में?
It is not division.
It is a service matter, no?
Service matter.
LPA.
Signature matter, Lordship.
Judge, how can you mention when we are sitting to
Civil,
mention on Wednesday at 2:15?
May I permitted, Lordship? Case number 37. I pray for 1 week time, Lordship. Item number 37. I pray for 1 week time, Lordship.
37. Granted.
Under the heading for orders on office note serial number 1, Prabhat Ranjan versus the Bharat Sanchar Nigam Limited for the petitioners to Amit Prakash.
Earlier notices were issued, my lord. It is for service.
Sixth, you have not furnished the correct address and all.
My lord, may I pray one thing, my lord? I would file a fresh notice, my lord. It may be affected through BSNL. He is a BSNL contractor.
No, why? What is? So who is the sixth respondent?
He is, my lord, the proprietor of Hans Telecom resident, Choti Kalyani, Muzaffarpur. I have instructions, my lord. I have instructions, my lord. Hans Telecom proprietor, it is there, in whose favor contract has been granted.
Correct. You have to give the correct address.
Lord, may I pray, my lord? I would do the dusty notice, my lord.
Sir is permitted to take dusty service on sixth respondent who has not been served with the present petition. Matter after 2 weeks.
2 weeks. Within 1 week, I would.
1 week.
Under the heading for admission serial number 2, Anand Gardhan Paswan versus the Union of India others for the petitioners Sri Arun Kumar Gupta.
You kindly pass it.
Lord, Lord, the case has been allotted. Lord, the case has been, Lord, come to me, my Lord, after another advocate, my Lord.
We congratulate you.
They have not given, Lord, the file, but they have, Lord, said, my Lord, in 1 or 2 days, my Lord, it will be, Lord, provided.
Yes, no interview, nothing.
Arguing counsel is not present.
Huh?
Arguing counsel is not present today.
Correct, but nothing survives in this matter.
I do not have copy of it. Kindly pass this.
Matter is of the year 2016. Even to this day, counter affidavit has not been filed. When counsel for the petitioner is also not prepared to address the argument in order to give an opportunity to read the matter next week. If the matter is not addressed, present petition would be disposed of with the available material on record next week.
Serial number 3, Abhay Kumar Singh versus the State of Bihar and others.
Draw this case. Matter is infectious.
Infectious. Infectious.
Serial number 4, Messrs. Brijnandan Singh versus the State of Bihar and others for the petitioner's fee of Bihar Ranjan.
Where is your counter affidavit?
Milord, sorry, Milord, counter has not been filed, Milord, sir. Some time may be given.
5 years is not
Yes, Milord, sorry, Milord, but Milord, at the last chance, Milord.
blacklisting for how many years?
10 years and 15 years. This matter is a similar matter. My lords have been pleased to fix lords on 11th. It's 483 of 2023. Pleadings are complete in that case.
Matter is of the year 2018. Till date, the order dated 19/11/2018 has not been complied by the respondent in filing counter affidavit. Release this matter on 11th. It is made clear that no further time would be granted.
Serial number 5, Mrs. SKP Enterprises versus the Bihar Police Building Corporation and others for the petitioner's fee, Ranjit Kumar Singh.
Case solved.
I am for the respondent also.
You got 32 solar units installed by some other agency.
So for that is concerned, Lord, for the first time, Lord, case has been listed today after a long gap, Lord. So only section, Lord, I am. And there was a quotation, Lord, that some work was changed, Lord. That petitioner himself admits. Or together, they were
The case for the petitioner, Land Council for the state / corporation is hereby directed to get instruction whether the remaining solar light units of 32 in number have been installed by third party other than the petitioner or not. Such instruction be made available by legislature but next week.
Serial number 6 of Gladithic Construction Private Limited versus the State of Bihar and others for the petitioner Sri Prabhat Ranjan.
Technical bid was rejected on what ground?
The technical bid was rejected because his performance was not good.
What performance?
He was not keeping, he was not fulfilling the terms which is.
Correct. Which condition? It is general in nature. Reasons for disqualification did not fulfill terms and conditions of NIT. What are the terms and conditions?
And for them, there was separation also, Lord.
Sir, what are the terms and conditions? Have you indicated in your counter affidavit?
Yes, Lord.
In which paragraph you have stated? Which?
Page 21, my Lord, will see. That is the conditions stipulated. And my Lord, we have filed counter affidavit also.
Sir, in counter affidavit, in which paragraph you have stated that which clause has been violated by him?
Belongs to page 26.
Huh?
Para 26, my Lord, we have stated.
Which is the relevant format that he is required to disclose the his earlier agreement was rescinded.
Because that is a part of SBD, Lord.
Correct. Where is that?
That I will have to just get that. Because that is.
Now, how to identify that your requirement is under so and so?
Because the affidavit which was supposed to file, because the provision of clause.
Correct. Where do you get that? Where is that clause is imposed on a bidder that he is required to submit this material?
That is not.
None of you for the petitioner and counsel for the respondents are hereby directed to produce material information insofar as para 26 of the counter affidavit. Whether is it in the format that the petitioner was required to disclose past events like termination of agreement or contract. We'll get this matter next week.
Serial number 7, Mohammed Jamshed versus the State of Bihar and others for the petitioner Sri Amit Kumar Anand.
Lord, the grievances of the petitioner are redressed.
Lord, counsel for the petitioner, grievance of the petitioner is stated to have been redressed. In the light of the aforesaid submission, the present petition stands disposed of.
Obliged, Your Lordship.
Come in purchase.
Obliged.
Serial number 8, Mrs. Roy Engineers and other versus the State of Bihar and others for the petitioner Sri Rajiv Kumar Singh.
Under the NIT, where is the requirement of furnishing proper M and N of Bihar minor minerals concession rules?
That appears though
Where is the NIT?
standard bidding document has not been annexed with the writ application.
Along with your counter affidavit, have you produced?
I have not produced the same
Then?
one, but we have stated that
Your statement is not sufficient, sir. You must.
but annexure 2, page 9, my lord, if my lord will see, because it
What is the 2?
that your lordships may kindly see now 1.
Annexure 2 is agreement.
Yes.
Ah.
And in 1, your lordships, it construed as part of this agreement and of the SBD. That is the standard bidding document, your lordships. In this agreement, word and expression shall have the same meaning as are respectively assigned to them.
Where are reading?
Page 2, page 9, your lordships.
9. Page 9 is the agreement.
Agreement. Second paragraph from bottom, my lord will see. Serial 1. In this agreement, word and expression shall have the same meaning as are respectively assigned to them in the conditions of contract, hereinafter referred to, and they shall be deemed to form and be read and construed as part of this agreement. That is SBD standard bidding document, your lord.
Where is that requirement, sir? That the petitioner or a bidder is required to furnish the form number M and N.
And then my lord will
M and N he has not. Political. And then that is required to be furnished along with the demand. Sir, how bidder will come to? But payment is correct. NIT, they are. Hey, where is the NIT?
Your Lordship, we need to file the rejoinder.
No, where is the NIT?
In my file, there is no counter affidavit, no any document. Your Lordship.
No, neither you have produced nor he has produced. How to find out that?
Your Lordship, 2-week time may be granted.
2 weeks is sufficient. 2016 matter. Respondents are hereby directed to produce the relevant document to indicate that each of the bidder was required to furnish M and N
form N
of Bihar, perform M and N of Bihar minor minerals concession. So as to apprise the decision of the respondent dated 6/2/2016 issued by senior project engineer, Bihar Rajya
Whole Nirman Nigam.
Nirman Nigam Limited. Release this matter next week. In most of the file, relevant document will not be produced by either the petitioner or respondent.
But if my lord will find from Rule 6, 40.
Sir, correct, sir. I do understand there is a pro forma. That is required to be filed by bidder. Where is the requirement? In your NIT, you have to give instruction to the bidder, no?
Yes.
That is required to be examined. If you are not prescribed, suppose if you are not prescribed in NIT, what would be the fate of the petitioner?
Because after completion of the work, that has, before making the payment, your lordship, that has to be made by the.
Correct. Where is that requirement?
Requirement is in the SBD. Must have been in the SBD.
Show us.
My lord.
Minor minerals concession rules.
Serial number 9, Indradev Singh Seva Sasthan versus the State of Bihar others for the petitioner Sri Ram Kumar Singh.
This case has become infructuous, my lord. That time has 3 years time has been already passed, my lord.
No, the work was allotted to some other person.
Press advertisement was done, my lord.
Huh? Press tender.
Press tender.
Matter is relating to providing generator Gopalganj district for a period of 3 years. The NIT was issued on 25/6/2016. The petitioner has sought for a direction to the concerned respondent for issuance of a work order. Matter is of the year 2000. Therefore, question of issuing mandamus at this belated stage do not arise. At this juncture, and counsel for the respondent on such fresh tender is stated to have been issued during pendency of the present petition. In view of these facts and circumstances, the present petition stands disposed of as it has become infructuous. Instead of generator, you mentioned contract for upkeeping, supply of food, washing of clothes, cleaning, maintenance of the campus, as well as the supply of power through generator.
Serial number 10 is withdrawn. Serial number 11, Sanjay Kumar Shah versus the State of Bihar others for the petitioner Sri Ram Kumar.
Blacklisting without notice.
Yes.
Will allow. Take another one, page 14. For an indefinite period. You are for respondent.
Yes.
Will allow the writ petition.
My lord, I will seek instruction.
Subject to payment of cost.
The last answer.
Matter is pending since 2016. Once again, we can't adjourn the matter. It's taken down. None appears for the petitioner. In the instant petition, petitioner has prayed for the following relief. Annexure 1 reads as under. Date is 17/8/2016. Reads as under. So, perusal of the blacklisting order, it is evident that no notice or the formalities have been complied before blacklisting the petitioner for an indefinite period. On the short ground that no notice and blacklisting for indefinite period, the petitioner has made out a case. Accordingly, writ petition stands alone. Annexure so and so stands set aside, reserving liberty to the concerned respondent proceedings in accordance with law. So the concerned authority is hereby directed to take note of judicial pronouncement in the case of JMC, CMC, UMC and isolator case. Taking action, the above action shall be taken completed within a period of 3 months from the date of receipt of this order.
Serial number 12 versus Supreme Enterprises versus the State of Bihar and others for the petitioner Sri Anurag Saurabh.
Your Lordship, it has become infructuous.
Serial number 13 Sanjeev Kumar versus the State of Bihar for the petitioner Sri Shola Sandavan.
B6 and B8. What is annexure 6?
Annexure 6 is the show cause notice.
Show cause notice.
Yes.
And
he has replied, my lord. Therefore, that has been annexure A. That's a agreement, my lord, for that is for the 6 month and duration. It has admittedly not completed, my lord. Thereafter, but that is the not the ground.
What is the ultimate decision of in annexure A8? His contract was terminated. What?
Well, he was blacklisted, my lord, for 10 years.
Blacklisted for how many years?
It's for 10 years, my lord, in the year 2016. Vigilance case was, my lord, complaint was there, my lord, and thereafter on the instant of the...
Is it for non-completion?
No, it's
non-completion of
misappropriation. Several works has been done, money has been withdrawn, but actually that work has not been done, and many quality-wise, my lords, when the inspection was done, every crack was found, and it was not, my lord, as per the agreement.
Have you taken action against your executive engineer?
My lords, there's all are recommended latest position, I don't know, but they have been deported.
He has retired from service, scot-free.
But my lord, vigilance case has been lodged, my lord, complaint, and my lord, there is direction for taking action against the executive engineer and all that. just stated that he has said, he is saying that final measurement should be taken. And what is final? Okay.
No, who has inspected the work and submitted report? From Annexure 6, can you make out?
Annexure 6 is the...
Page 22, you say that it is a show cause notice. In the show cause notice, there must be an indication with reference to inspection report.
My lords...
Who has inspected? Whether the inspection was conducted in the presence of the petitioner?
With respect to the my lord show cause, there is my lord that the work has not been done.
Correct, sir. It must be with reference to the inspection report, no? While sitting in office, can you make out whether he has completed work or not, executed the work or not? Who has given the inspection report?
That is a technical cell, my lord.
Where is that? Whether he has been given opportunity during the inspection, he was there.
The stand, and that has been, my lord, considered. And there
What he has taken? Inspection was conducted.
Page 23 is the show cause, my lord. Reply.
Correct. Has he taken the contention that during his presence or in his presence the inspection was conducted?
That has taken note in page number 29, my lord. The order of that.
Inspection was conducted?
Yes, ma'am.
On what date the inspection was conducted? Whether petitioner has been provided the inspection report copy? Behind the back of the petitioner, you have collected information and taken adverse action against the petitioner.
That has not been demanded, but whether that has been served or not.
Sir, correct, sir. Whether he should be given an opportunity, no? Can you conduct inspection behind the back of the petitioner? He says that 10 meters have been work has done. You say 8. In his presence, you have to prove, no?
No.
Only 8 meters.
That, my lord, in the show cause itself, my lord, he has said that the certain amount which has been taken, my lord, excess, my lord, that may be adjusted in another tender if this is the...
He is asking to adjust.
In this, certain works were not completed.
No, correct. He has accepted the...
Accepted that the money has been taken more
in excess.
In the excess what the work
Which
has...
paragraph he has stated? In Annexure 7, in which paragraph he has stated? Your statement, Mr. State Counsel, your statement is contrary.
Statement is there, madam.
No, sir, he has not stated that he has admitted. He has not admitted. On the other hand, he says that it is not proved.
My counter affidavit, madam, statement is there that...
Your statement is not sufficient, sir. How many times you want us to repeat?
No.
Get the original records. And counsel for the respondent state hereby directed to secure original records so as to ascertain whether the inspection of the work executed by the petitioner was conducted behind the back of the petitioner or in his presence, so as to come to the conclusion that respondents have paid excess amount to the petitioner. We reach this matter next week.
got, my lord, in the so-called para art. But next time, my lord, I will show. In para 8, my lord, is.
Sir, without reading the file, you can't make submission. Your statement is contrary to what he has given in writing. Nowhere he has admitted.
Well, that is what I.
But you are saying that he has admitted.
That is, I am saying in para 8, my lord. That, but my lord, in the next day, my lord, it will come and I will show.
Number 14, Abdullah Chaudhary versus Bihar State Food and Civil Supplies Corporation Limited and others for the petitioner Sri Divakar Prasad Singh.
Lord, sir. Tender was published, my lord, by Annexure 1, my lord. Subsequently, without opening the tender, it was given to private respondent, my lord, by Annexure 3, my lord.
Tender for what?
Tender for, my lord, transporting and handling agent, my lord. Transporting come handling agent.
Race tender already issued, my lord, Annexure 6, my lord. That period already completed, my lord. Annexure 6, page 52. 2019 itself, my lord. Second tender, my lord. Annexure 6.
Now, why this was cancelled? 2015.
My lord.
Without opening, it was cancelled and given to other.
Do any appointment, my lord. Some.
No, what is the reason?
NIT has already cancelled, my lord. NIT.
Correct, sir. What are the reasons, sir? Some of your relatives did not participate, therefore you have cancelled and re-invited. Reasons must be assigned, no? What is the reason?
It was given by Annexure 3 on 20% higher rate, my lord.
You have filed your counter?
Sometime I will go to file counter.
What sometime, sir? What were you doing for these many years?
My lord, second tender has already issued, my lord. Petitioners file application, Annexure 7, page 50.
Sir, the reasons must be assigned for cancellation. What is the reason? Matters of the year 2016 till date, counter affidavit has not been filed by the respondent. So, the respondent proceeded to issue NIT for transporting cum handling agent in the year 2015 without opening that, which proceeded to cancel and re-notify in the year 2016. The concerned respondent hereby directed to file personal affidavit as to what are the reasons or circumstances warranted for cancellation of NIT issue in the year 2015 and re-notifying the same in the year 2016. Such affidavit be filed before the next date of stay. This matter after 2 weeks.
My lord, only one submission, my lord. As per Annexure 4, my lord, page 27, my lord, the District Transport Committee has already considered and 3 persons, my lord, qualified and appointed, my lord. Petitioner's name already recommended to name including the panel in panel, my lord, page 24.
Correct. What is the reason for cancellation? Ask him to file a personal affidavit. What are the developments and all dates and events?
Serial number 15, Sanjeev Kumar versus the State of Bihar and others for the petitioner Sri Sanjeev Kumar.
And now it has become in purchase.
Purchase.
Serial number 16, Chandan Kumar Chaudhary versus the State of Bihar and others for the petitioner Sri Anirudh Kumar Singh.
My lord, prisoners challenge, my lord, the Annexure 8, page 47, a qualified person in transporting work, my lord, and district manager issue letter and direct to qualified person to execute agreement, my lord. That letter challenge this petition, my lord. And that period has already over, my lord, completed. Petitioners challenge Annexure 8, my lord, page 47. Those persons are qualified in tender process, my lord. Then district manager SFC directed to those persons to execute the agreement, my lord. Thereafter, work is already over, my lord. Agreement period is already over.
He is challenging some clause.
Annexure 847.
Clause 9.
No, but that this application is for quashing the letter number 2369 dated.
What is this letter? Annexure 8.
Annexure 8, page 47, my lord. District manager issued 4 persons in the name of 4 persons and directed, qualified persons, my lord, and directed to execute the agreement, my lord, for transporting work. Thereafter, my lord, agreement is already executed and work is completed, my lord. Tender period already complete. To say
In the instant petition, petitioner has no interim order. Full stop. Land counsel for the respondent on instruction submitted that contesting respondents have already executed the work. Therefore, nothing remains in the present matter. Accordingly, the present petition stands disposed of as it has become in purchase.
Serial number 17, Akhilesh Singh versus the State of Bihar and others for the petitioner Sri Raman Kumar Singh.
I am extremely sorry. I am the respondent to state lordship. File is not with me, lordship. File is missing. My file is lordship also missing, lordship.
File missing. We'll dispose this matter.
Lordship.
Take page 19. Blacklisting indefinite.
Debarred.
Debarment.
It is specified, but
no notice.
But if one more chance may be given to see whether what is the position. One chance may be given. Let's see, one chance may be given.
None appears for the petitioner. In the instant case, the petitioner has prayed for the following relief. First of Annexure 9, dated 22/6/2016, reads as under. Perusal of the aforementioned document, it is evident that the petitioner has not heard, like issuance of notice, obtaining the explanation, and proceeded to pass a speaking order. That apart, indefinitely the petitioner has been debarred in participating future tender. Indicated by the appeals court. Accordingly, the petitioner has made out a case, hence next 9 dated 22/6/2016 stands set aside. Writ petition is allowed, reserving liberty to concerned respondent to complete the process within a period of 4 months from the date of receipt of this order. The concerned authority is directed to take note of appeals court decision in the case of UMC so and so, isolator so and so, before taking further action in the matter.
Serial number 18 is withdrawn. Serial number 19, Rishi JB versus the State of Bihar and others for the petitioner Sri Manish Chandra Gandhi.
Matter has become infructuous.
Serial number 20, Avinash Kumar Singh versus the State of Bihar and others for the petitioner Sri Ms. Neetu Kumari.
My lord, this case has become infructuous.
Is your for respondent?
Yes.
Yes, for petitioner. Submitted that.
Serial number 21, Mrs. RL Enterprises versus the State of Bihar and others for the petitioner Sri Vikas Mohan.
Your Lordship directed to file counter affidavit. Till date, I have not received a copy of the counter affidavit. That is order dated 10/2/17, my lord. And अब 23 हो गया हुजूर, हमको भी स्थिति नहीं पता है क्योंकि इट्स ए कॉन्ट्रैक्ट मैटर. तो काउंटर हैज नॉट कम. 10/2/17 का ऑर्डर है हुजूर.
Must have become infructuous. No interim order.
That is why I have mentioned, my lord, कि इसका after हम जरा instruction ले लेते हैं. What is the position? Because it has come after long period. I have tried my level best to contact with my client. Let it come.
IA for 18, 2018.
Counter भी नया हो सकता है. He may be continue. Maybe some change has been taken place. I will bring everything before your lordship consideration. Because 17 का है हुजूर, 23 है. ऐसे जो ऑर्डर से मिला है इसमें यही ऑर्डर है. आउटसोर्सिंग से एम्प्लॉयमेंट था जब तक. Annexure 4 is the order, my lord. Annexure 4 is by which I have been given the contract.
The earlier contract has become infructuous since you yourself have filed IA for.
That I have challenged, my lord.
There is no interim order. Even that 22/17.
हम इसका हुजूर लीज पे नया काउंटर आया, इसको आफ्टर वेकेशन कर दिया. जो हो फैक्ट्स हम ला देंगे हुजूर के सामने. Because the employees are
cannot be replaced. What instruction?
Lordship, notice letter has already been issued on 20th January 2017.
No.
We haven't received statement of facts, Your Lordship.
So whether the petitioner is continued?
No idea, Lordship. Still, we haven't received any.
Get instruction by 2:15.
हुजूर बहुत ट्राई किया, हमसे नहीं कांटेक्ट कर पाए अपने क्लाइंट से.
Since you didn't get interim relief, so he has not contacted.
I want to bring the facts. Let it come after vacation. I will file an affidavit.
Why we should adjourn such old matters?
Because my lord, I am outsourcing. My EPF and everything is deducting. In case if they are continuing there.
Sir, you also get instruction by 215, sir, whether the petitioner is still working or not.
Yes, the petitioner has challenged the order passed by the respondent number 4, contained in Annexure 3, page 37, by which the petitioner has been debarred from the work and without giving any notice to the petitioner and allotted the work to another person, giving reason that his letter has been received, that his work is not satisfactory. Lords, the respondent also...
Where is the 17/6/2015 order?
Lords, page number 37, as Annexure 3, Lords. Earlier also, Lords, the petitioner has worked and his work was satisfactory, and the next year he has again filed applied tender, Lords.
We have not entered into agreement.
Lords, yes, Lords, after 1 month of satisfactory work, agreement has to be executed, Lords. He has demanded, he has made illegal demand for executing the agreement, for which I have filed the application before the vigilance, and vigilance.
Where is the agreement?
Where
is the agreement?
Agreement has not been executed.
Then what is your right?
Agreement, I have worked.
Without agreement, how did you execute the work?
Here, after 1 month, agreement has to be executed,
These are all the disputed facts. Go and file a civil suit claiming damages.
At 2 years, I have worked with outstanding amount.
Sir, all right. You go and file civil suit. In the instant petition, petitioner has prayed for the following relief. Is a manager 3. Dated 17/6/2015. It is undisputed fact that the petitioner has not executed agreement before taking up the work. Other part, the supply or construction.
Supply. Upkeep of the estate.
You are correspondent?
Yes.
Huh?
Yes.
Where is the notice before termination of contract?
I will bring it to the
Huh?
I will bring it from the department. I will produce it before the court.
You don't have a copy of the counter affidavit?
Because the file has not been.
File is missing.
The file is. In the counter affidavit, he has not annexed any notice to show that the petitioner has given notice prior to termination of the work.
Respondent authority without recorded, but it has not been answered. Instant petition petitioner has prayed for the following relief. Annexure 3 reads as the respondents are not specifically taken contention that the petitioner was heard before passing impugned order dated 17/6/2015, cited supra. Even the final order do not reveal as to whether the petitioner has been heard in the matter, like issuance of show cause notice and seeking explanation of the petitioner. In fact, the petitioner has specifically contended that impugned action is without show cause notice. Facts and circumstances, the petitioner has made out a case accordingly. Just 3 stands set aside. Writ petition allowed, reserving liberty to the concerned respondent to proceed in accordance with law within a period of 4 weeks. The concerned authority is hereby directed to take note of UMC's for decisions before proceeding further in the matter.
Serial number 23 versus Ryan Construction Private Limited versus the State of Bihar for the petitioner's fee is Mahina.
Lords, the supplementary affidavit has been uploaded, my lord. Its hard copy is there. If my lord pleases, I may submit the same. Because now, during the pendency of this certification, only the prayer number 3 is subsists. Because the work has been done, payment has also been made, my lords. And the impugned notice has not been acted upon.
Only prayer number 3 survives.
For that, my lord, if my lord may so pleases, I may submit the supplementary affidavit, bringing all the facts and records.
Have you appraised the authority, concerned authority, that you have completed the contract and
They have paid the bill itself. Everything is paid.
the respondent has to consider?
Lord, the executive engineer, lords. Executive engineer, lord. Respondent 5. See. Only the
for the following relief. Prayer number 1 and 2 do not survive for consideration. Used a prayer number only for a direction. Completed and executed the contract work, and the concerned respondent was required to
foreclose the contract
make
and foreclose.
In this regard, the matter is pending consideration before the 5th respondent, executive engineer. List of the executive engineer is hereby directed to decide the grievance of the petitioner within a period of 2 months from the date of receipt of this order. If the petitioner is otherwise not eligible, in that event, a necessary detailed speaking order should be passed.
All right.
From the Lordship will find
he has submitted wrong bill.
Wrong bill. That is the reason. For that purpose, you issue a show cause notice. Thereafter, proceed to pass order.
His DPR was itself faulty. That is why they have realized their guilt and they have made the payment of the works done.
Serial number 24, Mrs. R.S. Pandya and Company versus the Union of India Owners for Christmas tree product.
The last occasion, Your Lordship directed the Chief Engineer to present the report of the case. A simple prayer here, Your Lordship, that they have not constituted the appellate authority where I can. They have not constitute the appellate authority as in terms of clause 24(2) of the GCC, Your Lordship. There is a dispute redressal system in the general condition of contract.
Read the second prayer.
Second prayer.
Page number 2. Appellate body is constituted.
Your Lordship, the appellate body was constituted, Your Lordship. That is the empowered standing.
What is the date of constitution? So that the petitioner's grievance against the chief engineer order dated 26/5/2014 is required to be examined.
26. Your Lordship, the chief engineer is here.
On what date the appellate body was constituted?
Sir, actually the body is having 3 members, and out of the 3.
Sir, when the appellate body was constituted? After 10/12/2013, with reference to CWC 8160 of 2011, when did you constitute the appellate body? Whether appellate body is functioning or not?
It has already given its recommendation, sir.
It is still under consideration. 10 years plan?
No, sir, it has already given.
Sir, after 10/12/2013,
Sir,
orders of this court passed in CWJC 8160 of 2011. What is the date of constitution of appellate body?
The order of the appellate authority, Your Lordship, is on record 26/5/14. Order is on record, Your Lordship, 26/5/14. That is at page 40.
This is by empowered standing committee.
That is the appellate authority.
No, I guess this
Against this, Your Lordship, against this, there is no appeal, Your Lordships.
Against this, he has a remedy before some other
He has remedy before the civil court, Your Lordships, at page 226, Your Lordship will see 24.5.
Page number?
Page number, Your Lordship, running page is, I think, 226. On 226 of the affidavit.
Item number?
Item number, Your Lordship, 24.5.
24.5.
24.5. There is internal page 143. Your Lordships,
24.1.
24.5, Your Lordships.
5.
Standard bidding document. for PMG is filed. The decision of the Standing Empowered Committee will be binding on the employer for payment of claims up to 5% of the initial contract price. The contractor can accept and receive payment after signing as in full and final settlement of all claims. If he does not accept the decision, he is not barred from approaching the court. Similarly, if the employer does not accept the decision of the Standing Empowered Committee above the limit of 5% of the initial contract price, he will be free to approach the courts applicable under the law. Because next 25.1, Your Lordship says there is no arbitration.
Come after 24.2, Your Lordship, after appeal.
Huh?
This will come after appeal. Appeal, there is
No, sir. This is a Standing Empowered Committee.
Your Lordship.
After their decision, you have a civil court.
Your Lordship, come to may I have a look on 24.1.
24?
First, 24, clause 24.1, dispute redressal system. In the middle, Your Lordship, it described along with the, I'm reading from the beginning, if any dispute or differences of any kind whatsoever shall arises in connection with or arising out of this contract or the execution of works or maintenance of the works thereunder, whether before its commencement or during the progress of works or after the termination, abandonment or breach of contract, it shall in the first instance be referred for the settlement to the competent authority described along with their powers in the contract data above the rank of the engineer. The competent authority shall within a period of 45 days after being requested in writing by the contractor to do so. This is the first place where I can move, and thereafter, after grievance of the party will reach before the appellate tribunal, which is 24.2, and then comes 24.5.
Against which order you have approached the Empowered Committee?
I have approached after CWJC 8165. I was directed to represent before the competent authority, chief engineer, which I have filed. And they have passed the order as empowered standing committee.
Chief engineer is the competent authority.
Chief engineer is the competent authority, and if he was not the competent authority, he will refer the matter to the competent authority.
The constituency is already over. Now we have a remedy before only civil court.
No, Your Lordship, 24.2.
24.2, yes.
24.2 come to either party will have the right of appeal against the decision of the competent authority. I have after.
You have already approached against the chief engineer order before the standing committee.
I have come to an.
Sir, how did you approach?
After the.
Did you approach an empowered standing committee?
I have not approached before the empowered standing committee.
Then who
they have passed the empowered. They have constituted the empowered standing committee and passed the order.
The absence of appeal, how empowered standing committee proceeded to pass order?
They passed an order, Your Lordships, on 31/1/14. I'll just.
Where is that?
I'll read it. It's not on analytical record.
Contract data.
Record, Your Lordships. I've just asked for it. They've given it. Your Lordships, it says kindly refer to the above noted correspondence on the subject by which the Standing Empowered Committee has been constituted in compliance of judgment of the Patna High Court dated 10/12/13 in CWJC number 8160 of 2011. Following records are enclosed herewith to go ahead with the adjudication of the claims made by the petitioner contractor. Your Lordships.
Where is the power of a standing committee to consider this? Standing committee is empowered only to.
It's the appellate.
Appeal.
Appellate body. Yes, it's the appellate body.
Appeal is against which order?
But Your Lordships, what they have said was, what their Lordships have said in the writ petition was, if he is not the chief engineer is not the competent authority, he will send it to the competent authority. Now, in that view of the matter, the then chief engineer, he sent it to the appellate authority. That is what
directly referred to the.
Directly referred. So there is actually, Your Lordships, I will admit there is loss of one forum. That loss of one forum has.
So we will set aside and remand.
And he will decide within a fixed time. You are the competent authority, na?
No, sir.
No, where is the definition? insofar as competent authority?
At page 158 of the contract data, Your Lordship.
Who is the competent authority?
Where it is mentioned, competent authority are all the disputes are to be referred to the standing empowered committee.
Competent authority?
Or a standing committee.
That is the dichotomy because of which the chief engineer sent it to the standing empowered committee.
But this standing empowered committee is not directly entitled to consider unless only appeal is
provisions appear to be in conflict. Because there it says that the standing empowered committee will be the competent authority, and in 24(2) it says it will be the appellate authority. That is the conflict, Your Lordships, because of which the chief engineer, being overcautious, sent it to the empowered committee.
It was
but you have to go by clause 24.
Your Lordship,
24 and to complete 24.
Your Lordship, but because of the other provision, which says that the standing empowered committee is the competent authority.
Where is that? That the standing empowered committee is competent?
Page 158, Your Lordship. My paging is a little. इसी का है
What is this document?
General condition of contract.
This is the general conditions of contract.
But within bracket they refer to 24.1. How is it possible?
that is the Your Lordship's dichotomy, which Your Lordships may address and demand and pass order.
2011.
Clarify that because in other cases also the same confusion may arise, Your Lordships. So if Your Lordships were to clarify that. At page 158, Your Lordships may see clause 15. Competent authorities are all disputes are to be referred to standing empowered committee.
To this
कैसे करेगा इसके Your Lordships may also notice the monetary amount given. Standing empowered committee will be appellate authority if it is above 1 lakhs, which in this case is. And 15 at page 158 does not give any monetary.
Is it second round or third round?
Second round, Your
Third
Lordship.
round.
Earlier it was decided, directed to file
There
representation.
was also a contempt which has been disposed of against this.
Earlier litigation 2010.
Earlier, earlier were disposed of that it is a premature. So on that ground it was. But on 2011,
Once again you approach.
come and
That's the reason I'm asking you third round litigation.
third round.
And one contempt.
Because in the instant petition petitioner has paid for the following reasons. Petition is before this court on third occasion. The instant petitioner has prayed for the following relief. The petitioner's disputed issue is required to be adjudicated by the competent authority in terms of clause 24 of SBD for PMGSY. Whereas the appellate authority dash standing empowered committee decided the petitioner's dispute. The standard empowered committee is only an appellate authority in terms of standard bidding SBD for PMGSY. On the other hand, under the contract data, general conditions of contract, clause 15,
15A.
15. 15.
That is
A relates to competent authorities defined as a standing empowered committee. Within bracket clause 24.1 was referred. Reading of clause 24.1, 24, read with 15. It is contradictory in identifying the competent authority and appellate authority. In other words, competent authority has not been defined. Other than saying that all the disputes are to be referred to standing empowered committee. Even though appeal is provided for the standard empowered committee, under 24.2, it is necessary to introduce clause 24 is on page 225 and 226, and clause 15 page 241. Reading of the aforementioned provision, it is evident that identification of competent authority and appellate authority are overlapping. In other words, the petitioner dispute has been decided by the standard empowered committee, whereby the petitioner has been denied appeal under 24.2. Therefore, the chief engineer is hereby directed to decide the petitioner's dispute initially after giving the ample opportunity of hearing. Thereafter proceed to pass order whether the petitioner is entitled to any relief before the chief engineer or not. In this regard, a detailed speaking order shall be passed communicated to the petitioner, since in the event of any adverse order is passed against the petitioner has the remedy of appeal before the standing empowered committee under clause 24.2. The above exercise shall be completed by the chief engineer within a period of 2 months from the date of receipt of application / request of the petitioner claiming certain relief. The petitioner is at liberty to file additional claim, if any, in a period of additional claim, if any, by the on behalf of the petitioner, the chief engineer is hereby directed to take note of concerned material information and proceed to pass order. Sorry, yeah. Order of the expert committee stands set aside since without the power of the without the contrary to clause 24 read with clause 15 of the SBD for PMGS.
Here number 25, Ajit Carrying Private Limited versus the chairman lying that the Bharat Petroleum Corporation Limited.
Nephew Lordship. Petitioner has approached this honorable court for quashing annexure 3 at page number 18, Your Lordship.
Turn the mic.
Petitioner has approached this honorable court for quashing of annexure 3 at page number 18, Your Lordships. Earlier, this is the second round of litigation, Your Lordships. Earlier, while annexure 2 starts from page number 16, I have approached this honorable court whereby a direction was issued to approach before respondent number 2. Page number 16, Your Lordship.
Oh, but sir, what is there?
Your Lordships.
23/11/2018.
Yes, Your Lordship. By this, Your Lordships, my representation, which was pending consideration, was disposed of, Your Lordships.
What was your representation?
The representation was, Your Lordships, with regard to, Your Lordships, I am the transporter, Your Lordships. We have been selected after issuance of NIT to bid process, Your Lordships, and other documents are required. Whereas, Your Lordships, the petrol company provides on expression of EOI, on expression of interest, transportation work to the petrol pump dealers, Your Lordships, only through EOI, Your Lordships, without following any due process of law, Your Lordships. And by that, the petrol pump retail outlet dealers, Your Lordships, they have been also engaged in transportation work, Your Lordships, through EOI, expression of interest, for which, Your Lordships, no norms are prescribed. We are transporters, and we have to undergo two selection process, Your Lordships, by technical bid as well as reverse auction. And due to that infirmity, we have approached before the authorities requesting to just allow the others retail outlets also.
Oh, were you successful bidder?
Yes, Your Lordship, I was the successful bidder.
And what happened?
Your Lordships, since my my tank lorries only in a month only it travels up to 600 to 900 kilometers. And all because of this retail outlet dealers, Your Lordships, who have been provided to carry only to sell the petroleum products. They have been given license to sell the petroleum products through this expression of interest, which has been named as EOI. They have been allowed to transport that.
What is the condition in the tender?
In the tender, Your Lordships, there was no such condition, Your Lordship. There was no such EOI. After our tender, Your Lordship, this EOI has been issued, Your Lordship.
What is meant by POI?
EOI, expression of interest. EOI. Through this, Your Lordships, the retail outlet dealers are engaged in transportation of petroleum products, Your Lordships. And in rejection order, Your Lordship may kindly see, Your Lordship may kindly come to page number 20, Roman 3, fourth line from the top, Your Lordships. They say that the quality and quantity of the petroleum products will be maintained, Your Lordships. Your Lordships, since I am the transporter, I have to invest huge amount of money for buying these tank lorries and maintaining staff and everything, Your Lordships. And all because of this expression of interest, EOI, Your Lordships, we have been entire...
This expression of interest was introduced for the first time after NIT or before NIT?
It was after, Your Lordships, our rate had been finalized.
No, sir, where is this expression of interest order?
That is not on record, Your Lordships. I may be permitted to file a supplementary.
They have admitted in this Annexure 3 itself, Your Lordship, they have admitted.
Yes, sir, Mr. Where is this expression of interest?
It is not on
How it was generated? Is it after NIT or before NIT? If it is before NIT, he has no case. If it is after NIT, if it is before NIT, he has a case. If it is after NIT, you have no case.
Lordship, it has not been brought on record, Your Lordship.
What is this? Crucial matters are not brought on record. Then how to decide a matter?
Transportation is done through transporters and 50% is done through.
Whatever it may be, sir, why it has not been placed on record? In order to ascertain what is the object and of incorporation of expression of interest. When counsel for the respondent hereby directed to furnish necessary materials to the extent that expression of interest issued to petrol pump dealers is under which scheme and on what date such a expression of interest to petrol pump dealers have been floated by the respondent corporation in order to ascertain as to whether such incorporation of after NIT or before NIT dated 25/11/2017 or after. Release this matter after 2 weeks. It is made clear that no further time will be granted.
Should may kindly grant 4 weeks time.
No. 2018 matter.
Last.
Serial number 26 is adjourned for 2 weeks. Serial number 27.
26? I am appearing 26.
26, someone has taken time.
I am for the petitioner, my lord. The respondents have been directed to produce the original records, my lord. That is without any information that it has been done.
Time.
But I am appearing on behalf of the respondent.
He is for the private respondent, my lord. The institute has been directed.
My appointment is under challenge. I also wanted to have time, but I couldn't come at 10:30, so I will be praying for 2 weeks.
My lord, the order date
On
is
personal
19th of June, my lord. After 2 weeks, it comes there.
6/2/23, my lord, my lord. 6th of February, my lord. But please to direct the authorities to produce the records.
Sir, it is passed over tomorrow. It will come.
My lord, deeply on that.
Lordship, could I pray, my lord, for personal reasons, my lord, the marriage of the daughter of my advocate clerk. We are not getting any file, lordship. It is on personal ground that I am seeking time, lordship.
Next week.
The marriage is on.
No, your colleague is nodding his head next week.
No, he is not
for
the state. He is for the state, lordship. Marriage is on 16th.
It will be on the 15th, my lord, no later than
16th.
that. 15th, if it is not
16th is the marriage.
After vacation.
This is my lord, after having been satisfied and directed for production of the entire records. The person who was continuing as the director had gotten himself appointed as the professor.
Lordship, I have retired in 2020. Not that. Lordship, the marriage is on 16th. That is why I was praying.
After vacation.
I would not have prayed, Lordship, because of personal. It is on account of personal reasons.
3-4 dates, my lord, after 16th February, the matter was adjourned at their behest. I'm not ascribing any intention, but
circumstances we have to see.
My lord, yes. Oblige, my lord.
Serial number 27, Mrs. Jayama Durga Travels versus the Union of India for the petitioner Sri Padma Trivedi.
You may see the last order.
Why nobody appears for Union of India?
Your Lordships, in this case, what has happened, Your Lordships, today the GM safety is here, Your Lordships.
Not today. On the previous occasion, there is no representation.
This matter was of 2019 and one lawyer appeared. Thereafter, during Corona, Your Lordships, nobody appeared. Then after Corona, when the case was listed, in the meantime, Your Lordships, there had been a change in councils. The railway central government councils has started looking after the case. And unfortunately, Your Lordship, this particular case missed out from the list. So no other lawyer was assigned. And it is only when Your Lordship's notice went that they were realized they were able to trace out the file. And thereafter, counter affidavit has been filed, Your Lordships.
4 times.
I'm sorry, Your Lordships.
Nobody appears?
I'm sorry, Your Lordships. That was because of the file somehow went missing and they couldn't have knowledge because the counsel who was appearing before Corona, Your Lordships, he was not appearing thereafter and there was lack of communication in between them. I'm sorry, Your Lordship. That is a fault on our part. Counter affidavit has now been filed. Also an IA, Your Lordships, for exemption of appearance of the GM for today. There's also an IA, Your Lordships, to exempt the appearance of the General Manager for today. The 2 persons had been called. One of them is here, Your Lordships, and for one of them we filed a petition for exemption just for today.
What is the reason for discontinuation of supply of vehicle?
Your Lordships, is because his work was not proper, Your Lordships. He was terminated.
12/4/2017, sorry, 28/2/2017 order?
Your Lordships, he was given due notice and thereafter it was terminated and there's a...
Correct, where is this 28?
My lord, in this some instruction is required after filing the counter affidavit. Petitioner is not in Patna. Actually, my counter was received in my office on Friday evening when I had already left for my village.
You have filed your local? Then I argue the matter.
Some instruction is required for
that order, Your Lordships, is last page of the writ application, Your Lordships. 28/2/2017 termination notice. That is the last page of the order. Page 71. At page 70 is the 7 days notice.
Where is this clause 62 of GCC?
Clause 62, Your Lordships, of page.
Page 62.
That is page 62 of our counter affidavit, Your Lordships. Starts from This is also quoted in the counter affidavit, Your Lordships. Starts from page 60.
My lord, letter of acceptance was petitioner. After putting signature on the general and special term and condition of the agreement, wherein there is a special provision for arbitration.
Special provision for?
Arbitration also.
Arbitration.
Arbitration clause is there.
Where is that arbitration? Clause 63. 64.1.
64.
69. Page 69, my lord, of the writ petition.
Oh, sir, class 64.64.1.1. Demand for arbitration.
My lord, the petitioner has represented through the before.
All right, go and approach arbitrator.
Arbitrator was not appointed, my lord.
No, you have to appoint. You have to demand for appointment.
I have demanded, my lord.
Huh?
But arbitrary action was taken against me.
Huh?
I had demanded for the.
Where is the demand?
My lord.
There is no demand.
Fund.
Annexure 10 series, my lord. On page
10.
Page 57.
Filed by you.
My lord.
Where have you demanded? You pinpoint.
My lord.
Because it runs to Annexure 10 series.
My lord, on page 62. My lord, on page 62, may kindly see.
Page 62.
It reads as follows. अतः श्रीमान से प्रार्थना है कि अति शीघ्र निष्पक्ष कमेटी बनाकर उपरोक्त मामले की जांच की जाए तथा मुझे अपनी बातें एवं सबूत कमेटी के समक्ष रखने का मौका दिया जाए.
Not demand for arbitration.
My lord, this demand has been made by a layman.
Into the matter.
Layman person.
They are not specifically demanded. Arbitration is required to be held.
My lord, this letter has been written by a layman person. That's why.
Layman person, so also where there is no material to show that it has reached the other side. Why we should not draw inference that this has been created for the purpose of filing this petition?
Oh my lord,
Then show us that it has reached the office of the respondent.
Letter has been written on 13/2/2000.
How it has written? How to establish that this document has reached the other side? So you must have obtained a seal and signature, no, of the concerned office, having submitted this.
They were not cooperating, madam.
Then have you taken such contention? Show us from the pleadings that even though I approached them stating that I am interested in arbitration, however, it has not been entertained. Where have you pleaded? In which paragraph you have pleaded? If you have pleaded, they would have countered it in the counter affidavit. There is no interim order. Petition has become infructuous. Why you want to pursue?
See,
they have withheld your EMD or something. EMD has been withheld.
beg your pardon, your lordship.
That claims to fight for arbitration. Is taken in the instant petitioner has prayed for the following relief. Petitioner was a successful bidder insofar as supply of certain vehicles in safety department of East Central Railway. He learned that he was irregular in supply of vehicles in the safety department. In this regard, there were certain communication from the office of the Deputy Chief Safety Officer / SLT ECR Hajipur. He learned that the petitioner has not mended his ways in supplying vehicles on regular basis, which has resulted in issuance of a show cause notice of termination on 28/2/2017. Sorry, 16/2/2017. Thereafter, the concerned respondent proceeded to debug the petitioner. The contract, terminated the contract in terms of clause 62 of general condition of contract. And balance work would be carried out independently without participation of the petitioner. Further, it is ordered that he is debarred from participation in the tender for executing the balance work, and his security deposit has been forfeited and performance guarantee also encashed. there are certain disputed facts. So notice is not specific so far as debarring him from participation in the tender for executing the balanced work commands, forfeiting security deposit and performance guarantee, encashment of performance guarantee. On these three issues, there is no specific notice. Notice is only in respect of taking action in terms of general conditions of contract, read with clause 62 of GCC. Sorry, so far as forfeiting of security deposit and performance guarantee is concerned, respondent is hereby directed to issue a detailed show cause notice, a fresh detailed show cause notice, to upon receipt of petitioner's explanation, proceed to pass final order of speaking order after due consideration of petitioner's explanation. If a respondents passed any adverse order, in that event, the petitioner is at liberty to invoke a remedy under clause 60 bracket 1, again within bracket 1, demand for arbitration. If such a demand is made by the petitioner, the concerned authority is hereby directed to arrange for arbitration. 24? Arbitration. Read with clause 24 of the agreement, it is so and so. Page 67. No, date of the agreement. Okay.
What is date of annexure 11?
What is the date of agreement, sir?
The petition is eligible like this.
Okay, in terms of agreement, so and so.
Number 28, C. Kumar Singh versus the State of Bihar.
That petition is disposed of. Lordship, the IA for exemption for today may be
For that you mentioned that IA number so and so for personal appearance of so and so stands distance. IA stands disposed of. Thereafter main matter.
On 1st September 2022, my lord, the respondents were directed to produce the original reports.
So,
on service.
My lord.
What is the date of charge memo?
My lord, the date of charge memo is, my lord,
13th June 2001.
Huh?
13th June 2001. 13th June. 13/6/2001.
23rd June 2001, my lord. Charge memo.
Description, where is the charge memo?
Charge memo is, my lord, Annexure 8, my lord.
What was the post held by the petitioner? What was
He was clerk in copying section, my lord.
where in district court?
My lord, subdivisional court, Jhanjharpur, my lord. Under the Justice of Madhubani district court, my lord.
Charge sheet at page 32 and it is dated 13th June 2001 as I stated.
transfer from the to Madhubani.
Exactly.
1998. Charge memo 13th June. Doubt.
The material. Tampered. Number 4 is
Singh. Since 10th of
Charge memo is supported by statement of input. Governed by which rules? Disciplinary rules.
He is bound by Bihar Civil Court Staff Class 3 and Class 4 Rules 1998.
What is the year of issuance of rules?
1998.
98. Which is the relevant rule? Initiation of inquiry.
The Rule 18 prescribes that penalties can be specified under the Bihar and Odisha Subordinate Service Discipline and Appeal Rules 1935. That is the state government rules. The rules which has been prescribed by the state government, which is of the year 1935. That is to be followed in case of the petition.
What is the 1935 rules? The 1935 rules provides statement of imputation, list of documents.
Learned single judge came to the conclusion that the petitioner did not cooperate in the departmental proceeding. After memo of charge was served, he just said.
First of all, we have to see the foundation, whether have you followed the rules or not. Where do you get this rule 160 to 170 of Bihar Odisha miscellaneous rules 1939? Odisha.
Votes listed.
You have this rules. 1958.
Lordships, relevant extract.
166.
167 is the proceeding of Lordship.
No, 166.
Lordship. Dismissal, removal, or reduction in rank.
Statement of allegation, where is that? Charge is there. Statement of allegation?
Lordship, if your Lordship may rule 167, which is proceeding under the heading proceeding, it 167. It is under the heading proceeding. The proceeding shall be drawn up in the form given in Appendix K and shall contain the following particulars: name, rank, and grade of the officer proceeded against, details of charges. Every charge must be specific. Charge should be drawn up and separately numbered, and should give the date, occasion, and nature of the offence committed. A copy of the charge should be given.
No, this is in respect of proceedings to be drawn by the inquiring authorities. 166 is the relevant. Where is the statement of allegation? And specifically it says that the grounds on which it is proposed to take action shall be reduced to the form of the definite charge or charges, which shall be communicated to the person charged together with a statement of allegation on which charge is based,
and any other circumstances which is proposed to take into consideration.
Who has adduced the evidence insofar as tampering of attendance?
Lordships, the statement of imputation is there. I find that along with the memo of class.
Statement of imputation is there.
The entire order sheet, if I have got the case record.
Then it has not furnished to the petitioner.
It is in the form of order number 98 of 2001. Lordship, so far as the allegation against the petitioner is concerned, that was...
There are twofold. One is he was transferred and he failed to report within the time limit. There is a belated. And second charge is on 2 spells he remained unauthorized agent. And the allegation is he tampered the attendance. That is overwriting or something. Now we are concerned with the overwriting because it's a serious offence. Who has proved? Who was the custodian of the attendance book?
The Shiristadar Lordship.
Then how is it passed on to him?
It has been recorded that any alteration can be...
No, sir, Shiristadar has he given his evidence that he has snatched my attendance book and tampered it. Then how did he, how he will get access to that attendance register when Shiristadar is the custodian of the attendance register?
On this aspect, Lordship, I will have to see the reports.
Yes, sir.
My lord.
On what ground you are challenging?
My lord, the complaining officer, my lord, was made the inquiry officer.
Complainant?
The officer who has complained against me has been in charge judge Nazarat and administration.
Charge?
Charge judge Nazarat and administration.
Incharge judge.
Judge, yes, my lord.
What is meant by that? Incharge. There is a post called judge.
That is written in the. My lord, a complaint was made by.
Where is a copy of the complaint?
My. That is written in Annexure 7, my lord, page 30. प्रभारी न्यायाधीश नजारत एवं प्रशासन व्यवहार न्यायालय झंझारपुर मधुबनी ने अपने पत्रांक स्वयं दिनांक 10 मई 2001 के द्वारा निबंधक व्यवहार न्यायालय मधुबनी को सूचित किया है कि श्री शशि कुमार सिंह सहायक लिपिक व्यवहार न्यायालय झंझारपुर दिनांक स्वयं को व्यवहार न्यायालय झंझारपुर में योगदान दिए। दिनांक स्वयं से दिनांक 3 नवंबर 2000 तक वार्षिक अवकाश था। श्री शशि कुमार सिंह दिनांक स्वयं से दिनांक उपस्थित थे, परंतु and that officer has been made the inquiry officer, and he has been made the inquiry officer, my lord. He conducted the inquiry, and even, my lord, he is so biased, my lord, that he has submitted inquiry report, and the finding is that ऐसा लगता है कि उन्होंने सेवा का परित्याग, अतः उनके कारण परीक्षा को अस्वीकृत करते हुए उनकी सेवा समाप्त करने का आदेश निर्गत किया जाए। He has recommended.
What is his name?
My lord.
What is his name?
Name, my lord. Pradeep Shah. His name is Mr. Pradeep Shah.
A district judge has entrusted the inquiry to Pradeep
Shah, who has made complaint against me.
Complaint is part and parcel of inquiry.
My lord.
It has been exhibited as what?
He has complained that I have.
Correct, sir. It has been cited in the inquiry, no? As exhibit as what? Exhibit A, B, C, D, or exhibit 1, 2, 3?
No, my lord. No documents were exhibited, my lord.
No documents. Not even attendance. Attendance, the allegation is that you have tampered